Čast i zadovoljstvo mi je da vas pozdravim ispred Srpskog udruženja pravnu i socijalnu filozofiju, koja je jedna od organizatora, naravno zajedno sa Pravnim fakultetom, ovog kursa ove godine u svesrdnu podršku Društva sudija Srbije i uz podršku takođe Advokatske kancelarije TSG. Kurs je, kao što znate, organizovan na temu Teorije, prakse, pravnog rasuđivanja. Postoji već 5 godina i mislim da je ovo prva godina kada je zainteresovanost polaznika, odnosno onih koji su aplicirali, tolika bila da smo stvarno imali veliki problem kako da napravimo izbor i kako da dobijemo ovaj na kraju prošireni broj polaznika kursa. S obzirom da je naš prvi predavač profesor Kenneth Himma, naš stalni gostujući profesor, pretpostavljam su neki od vas imali prilike već da ga slušaju, ja ću u narednih minut, dva još nešto reći, ako nije problem na engleskom jeziku, prosto da bi i on mogao da razume to što govorim, jer osjećam da je važno za ono što će i on imati da nam kaže u današnjem predavanju. So can I switch to English now?
Yeah, because I'd actually like to know what you're saying. Talking about me in Serbian, I don't know. Oh, okay. All right, cool.
Okay, so I will come up with a very bold statement that those who are in charge of organizing this course, and we are mostly, and you know us, we are mostly teachers from the courses that falls under the heading Theory or Philosophy of Law, are doing much, much more for your future practice than anyone else dealing with positive law on this faculty. I'm not satisfied with the things as they are. I would like that they are also contributing to this goal, but I want to explain this very bold statement. In a way, the reason why you would not expect us to be organizers of one such course is an old way of thinking that theory and philosophy of law are somehow completely devoid and separated from legal practice. And this could not be further from truth. Because legal theory and legal philosophy cannot operate without legal practice. All the material that we have to work with comes from legal practice. So we are obliged to follow and to work with what we have from the legal practice. The opposite is not necessarily the truth. So legal practice is in no way obliged to follow what legal theory says. From our point of view, this might be a sad thing, but it's just the way it is. Not only here, I would bet that it's the very same in the United States, but I would also bet that their legal theory has a far more influential saying in what legal practice does. On whatever level of legal practice we are speaking about.
You're forgetting we're the nation of Trump right now, so I don't know if that's true. But.
Okay, you are over-influenced by what is happening in your country at the moment. So let's forget it.
Okay, let's forget about my country.
Yeah. I wanted to make this bold statement just in order for you to realize that we're very glad to hear some of your submissions coming up with exactly this kind of explanation or reasoning why you want to participate in a course like this. A number of you spelled out very clearly and loudly that they consider this to be very important for your future practice. And we sincerely believe that this is so. And in that respect, we really hope that you will enjoy following 3 days and following 3 group of lectures, because as you know, we have each day 2 lectures combined with more theoretical and more, so to say, practical aspect of the theme. And today we start with Professor Kenneth Himma, and he will speak about the, as you can see, theories of constitutional interpretation. So basically, he will speak about the theories which are dominant in the American jurisprudence, in the jurisprudence of the Supreme Court of the United States, and this will be followed by the presentation of our judge, Dragana Boljević, who will speak about the problems which are more, so to say, confined to civil law systems or to our continental legal system, but I'm pretty much sure that both lectures will be connected by some of the common themes. So, without further delay, the floor is yours.
Okay, well, we're going to have to forget, I think we're done forgetting about my country, because I'm going to be talking about theories of constitutional interpretation in the U.S., and I'm not particularly well versed in constitutional practice in Serbian law, so the best I can do is talk about what's going on in the United States. Now, let me just say a couple of things by way of introduction. The topic of how the Constitution should be interpreted is an extremely important topic. It's a topic of great moral importance, something that I think, I hope will become evident to you as the conversation progresses. Constitutions do 2 things. They set up a legal system. They set up the blueprint, the recipes for making, changing, and adjudicating law. That's a necessary function. Every constitution that there is sets up a legal system and defines the rules by which laws can be made, changed, and adjudicated. That's something all constitutions have in common, whether they're written or unwritten, and I think there can be unwritten constitutions. The second thing that constitutions can do is it provides certain protections to citizens against the state. The Constitution in the U.S. contains the Bill of Rights, and the Bill of Rights limits what democratically enacted lawmakers can do by way of coercively restricting freedom. And there are a couple of points I want to make about the moral significance of this. The first point is, if you take a look at the basic job that every constitution does, it sets up a form of government. And it matters morally what kind of government a constitution sets up. Whether a constitution defines a democracy or a totalitarian system or some other system is a matter of great importance to all of us. Whether or not a constitution protects certain rights, free speech and so on, matters morally. So constitution, the topic, just the issue of what kinds of content a constitution should contain is of tremendous moral importance. Now, constitutions they're texts, and texts have to be interpreted. And as you'll see, different theories of interpretation can result in radically different results, depending on which theory of interpretation you use. All of that stuff matters tremendously from a moral point of view. So we're going to look at a number of different theories of constitutional interpretation, and we'll look at examples of the difference it makes with respect to cases that are very, very important in the U.S. In fact, some of the cases that we're going to be discussing, if you're following the election in the United States, you've probably figured out that people in the United States are quite angry right now. And there are a number of things, there are a number of cases that people are really, really angry about. The Supreme Court holding that legalized marriage equality, Roe v. Wade, which legalized abortion rights. There are now concerns that since Antonin Scalia died, that President Obama will appoint a Supreme Court justice who will interpret the Second Amendment, which which in some sense provides a right to bear arms in a very different way than Scalia interpreted it. So a lot of these cases are actually behind all of the anger that's going on in the United States presidential campaign right now. So I hope you find this stuff interesting. Okay, so let's move on to the first, try to figure out. The first theory of constitutional interpretation. First, I want to make a distinction. Actually, can we open some windows? Because I'm already warm.
Yeah, we'll open a couple.
There are two different types of theory of constitutional interpretation. Fixed content and living tree theory. A fixed content theory of constitutional interpretation holds that the meaning of the Constitution is fixed. It never changes. It cannot and should not be changed. So the Constitution, whatever its meaning was, it was ratified in 1787. Whatever the meaning was in 1787 is fixed in some way such that the content can't be changed. The second class of theories of constitutional interpretation are so-called living tree theories. Living tree theories hold that the meaning of the Constitution should change as circumstances in society changes. And so we'll begin with what is, I think, the most important and controversial theory of constitutional interpretation, originalism. Okay, originalism is the view that the meaning of any piece of constitutional language is determined by what people thought it meant at the time the relevant provision was ratified. So on an originalist view, what the Constitution means is what ordinary people understood it to mean in 1787. And so when you're deciding constitutional issues, the only relevant evidentiary considerations are the historical record. What did people think? You might look to the legislative record, or you might do something as simple as look to dictionaries that were published at the time the Constitution was ratified. Now, just to give you a sense for what kind of difference a theory of constitutional interpretation can make with respect to results, I want you to look at the Second Amendment. The Second Amendment provides, quote, a well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, what do you think that means? What kind of a right to bear arms do you think that provides? Just looking at the language, straight up looking at the language. Do you think that gives me a right to own a handgun?
It doesn't say carry.
Huh?
It doesn't say carry anywhere, so there isn't the issue of rejecting that as well.
Well, that's one concern. Yes, sir.
I think it might be interpreted only as a foreign hostility, not in domestic cases.
And what makes you think that? That's really beautifully done. I agree with that. Not that matters. I'm nobody, but I think that's absolutely right.
Because I think that the problems in currently in the United States might as well derive from this matter because so many homicides result because of people can really carry their guns around.
Oh, there's no question about that, but I think that there was something in the wording that you noticed, the wording of the Second Amendment, that made you think that it's limited to dealing with foreign threats.
Yeah, well, it's necessary to the security and militia.
There you go. A well-regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. Now, if you just look at the language, that doesn't seem to suggest that individuals have a right to bear arms, to handguns for self-defense. It suggests that people have a right to bear arms as part of a militia to protect against foreign threats. Now, intriguingly, the Supreme Court had considered the issue of whether or not the Second Amendment provided an individual right to bear arms that would allow me to have a handgun just for self-defense on several occasions. On every occasion except once, they held that it did not, until Justice Antonin Scalia, who recently passed away, which, to be perfectly honest, I'm okay with. God rest his soul, but the world's a better place without him as far as I'm concerned. He wrote an opinion. He's an originalist, and he's one of the most important and influential originalists there are. And he wrote an opinion holding that the Second Amendment provided an individual right to bear arms. Now, if you take a look at the wording, it seems implausible to think that ordinary people at the time the Second Amendment was ratified would read this or understand this as providing an individual right to bear arms. So Scalia, and this is something that always bothered me about him, forgive me, some political commentary is going to be necessary, is inevitable when I give a talk. And you're just going to have to, I have opinions just like you have opinions. Recognize that when I give an opinion like this, it's just my opinion. I'm not an authority on the matter, but I have strong feelings about this. Scalia, who claims to be a staunch originalist and is one of the most prominent defenders of it, or was before his death, violated his own theory of constitutional interpretation by holding that the Second Amendment actually gives gives people an individual right to bear arms for the purpose of self-defense. Now, what difference does this make? The murder rate in the United States is, as a whole, is 10 people per 100,000 people. The murder rate in Belgrade as a whole, I think, is three persons per 100,000 people, right? And this is 10 per 100,000 in the U.S. as a whole. You start talking about cities like Chicago and New York, that rate goes way up. As you know, we have a problem with guns. We got a big problem with guns in the United States. You think theory doesn't matter? It matters. Because if we had serious gun control laws in the United States, we wouldn't have as many gun deaths as we do. And it seems obvious to me that the U.S. would be a better place for it. And again, just as a side note, one of the things that people who are on the conservative end of the political spectrum worry about, and obviously I'm not on the conservative end, is that if Obama makes the Supreme Court, if it makes an appointment to the Supreme Court, he's going to nominate someone who will help to reverse the holding that interprets the Second Amendment as giving an individual right to bear arms. Because that vote went 5-4. Scalia was the deciding vote, and he wrote the majority opinion. Theory makes a difference in practice. The second case, Obergefell v. Hodges, legalized gay marriage. Now, this is kind of let me be honest about my views. I'm a marriage equality guy, I'm a gay rights guy. I have absolutely no problem. In fact, to say that I have no problem understates it. I'm in favor of Marriage equality. I think gay couples should be treated the same as straight couples. That's just me. Right? You don't have to agree with that. Now, Obergefell legalized gay marriage on the ground that the U.S. Constitution guarantees equal protection of the law to all persons. The Equal Protection Clause was ratified in 1868. At the time, gay marriage was prohibited in every state, but homosexual sexual activity was prohibited in 32 of the 37 states. Now clearly, the Obergefell case relied on a different theory of constitutional interpretation. If they had relied on an originalist theory of interpretation, the result would have been the opposite. Theory makes a difference in practice. Third case. Well, you know, we had a little problem with racism in the United States. Slavery. And now cops shooting unarmed black kids. You know? Plessy v. Ferguson was another equal protection case, Equal Protection Clause case that was decided in 1896 that held that public schools could segregate white and black students by placing them in different schools. At the time, states would actually build one school for white people and another school for black people. Not every state did this. Every state allowed public school segregation. Some states in the South, required it. Plessy v. Ferguson, so most states had laws then, again, either allowing or requiring racial segregation in public schools. An originalist theory then gets you what Plessy held, namely that public school segregation was okay. As we'll see when we get to other theories won't reach the same result. They'll reach an opposite result. And fortunately, in 1954, Plessy was overturned by a case called Brown v. Board of Education, which we'll discuss. So, originalism is one theory of interpretation. It's a fixed content theory. You see, the meaning doesn't change. What the texts mean is what it meant at the time the text was ratified. Now, all I've done so far is give you some examples of how originalism works and what difference it makes with respect to the result of the case, which theory of constitutional interpretation you hold. Now the issue is, well, why should we think, or should we think, that originalism is a morally appropriate or morally legitimate theory of constitutional interpretation? See, these underlying issues are all moral. When we just start to think about what law should be on the books, what behavior should be criminalized, look, law and morality are separate, but it seems to me that any conscientious legislator or judge, well, let's leave judges out of it for now. Any conscientious legislator will want to enact laws that are moral. It's hard for me to, well, it's not impossible for me to imagine a legislator who doesn't care about morality. I live in the U.S., and, well, we do some insane things in the U.S. when it comes to making law. Well, one argument for originalism is this: judges cannot legitimately make law. The role of judges is to apply the law and not to make it. So on this view, any judicial lawmaking whatsoever is illegitimate, morally wrong, and so the conclusion would be originalism is the correct theory of constitutional interpretation. Does it work? Is it true that judges can never legitimately make a law?
No.
Okay. I heard no. Yes, please.
I think it's not true because judge interpretation actually makes a new law. Because when you interpret the law, the text that was made, I don't know, 2 centuries ago, and you give him the new new aim actually, because we have, you know, the law text at one point in history didn't have the same aim as we have it today, right? So actually when judge gives a new interpretation, it actually makes a new law, because it's new the segment of the view of the judge.
Well, okay, that's a really interesting argument, but what your argument gets is a weaker conclusion than, it addresses a slightly different issue than the issue I'm raising. The argument you made says this, that judges do it. The question is whether it's legitimate for judges to do it, whether it's morally okay for judges to do it. I think you're absolutely right that they do it, and I'm going to make a stronger claim than that. It's not only unavoidable in some cases, and I think that what I'll have to say harmonizes with what you say. I'm going to say, at least in the United States legal system, there are times where judges are expected to actually make new law. For example, in the U.S., and forgive me, I'm not terribly familiar with the particulars of the Serbian legal system. In the U.S., we have three sources of law, or types of law. There's the common law, there's statutory law, and then there's constitutional law. The difference between statutory law and common law is this. Common law is explicitly left to judges to develop. Judges are permitted in the United States, presumably because people believe it's morally legitimate to make law. In the case of statutes, legislators do something very interesting, it seems to me. Now, this is a hypothesis. All right, this is a hypothesis. You'd have to go out into the world and ask legislators what they're thinking when they make laws in order to verify this. So this is a hypothesis that would have to be verified by some kind of sociological study. But it seems to me that when a legislator crafts a statute, the statute is crafted in general language for a number of reasons. One, if you try to be too specific in drafting a statute, the statute will be hundreds and hundreds of pages. But the second reason is that legislators know they can't foresee every kind of case that will arise under the law. So they deliberately frame statutes in general language, expecting judges to figure out how it applies in different cases, and thereby the legislators actually condone and expect judicial lawmaking. And the same, quite frankly, it seems to me, and again, this is, everything that I say is an argument. It's subject to dispute. I'm not the law with respect to anything. These are all theories and they're arguments. Whether or not you buy the argument is up to you. I do my best to try to give an argument that you'll accept, but I may not succeed. Seems to me that the same was true of the Constitution. The First Amendment, for example, says, Congress shall make no law abridging free speech. What the hell is free speech? What does that mean? Certainly, if it means anything at all, it means political speech. If it means anything at all, it means religious speech. But what about abstract painting? Does speech include abstract painting? Does it include dance in the U.S.? It does. Does it include pornography? In the U.S.? Yes, it does. Pornography, that's the good news if you ever come to the United States. In the United States, pornography is protected speech. But you see, right, you can't just look at the text of the amendment and figure out what it covers. And people who frame statutes know that, and undoubtedly people who framed the Constitution knew that as well. They knew that judges would have to work out the particulars of what free speech covered, and that's what they've done over the last 200 years. So, look, whether or not you buy this argument is up to you. I mean, like I say, it's just an argument. I'm trying to persuade you. I may succeed or I may not, right? I'm no authority. I don't have infallible access to the truth. So this is just an argument. A second argument that's really interesting, it looks like it's the same argument as the first one, and it's related to the first one. What? But it's different in an important respect. Unlike the first argument, I mean, the second argument says something about the role of judges. And the first argument said something about the role of judges. According to the first argument, judicial lawmaking is always illegitimate. This also makes a claim about the role of judges, but it's more specific. It applies only with respect to the Constitution. And actually, that makes sense in a way, because constitutions, statutes, common law do different things. You would expect that there would be different practices associated with each depending on the purpose of the relevant source of law. Here's the argument. Judges must interpret the Constitution in accordance with the meaning of the text. Well, that seems reasonable. I mean, even I'll buy that, and I'm extremely liberal. Second premise, the meaning of the constitutional text is the original understanding, right? And that claims that what the Constitution means, what a particular provision of the Constitution means, is what ordinary people thought it meant at the time that piece of text was ratified. Therefore, judges must interpret the Constitution in accordance with the original meaning. Wow. That looks pretty good, doesn't it? There's a problem with this, and it's a really interesting problem. Just anybody see it? It's very subtle.
You must interpret the Constitution in accordance to the original meaning. Why do they have to according to the original meaning?
Oh, well, look, this is, okay, these two claims, if these two claims are true, this has to be true. If it's true that judges must interpret the Constitution in accordance with the meaning of the text, then the meaning of the constitutional text is the original understanding.
Yeah, the second one is the only one that's problematic, actually.
Huh?
The second one is the only one that's actually problematic. The meaning of the constitutional text is the original understanding.
Why is it problematic?
Because the times change. It's simple. We need to adapt to different situations, and if you constantly follow the law as it was originally, and who says what it originally meant? Who decides that?
Well, I don't think that's an objection to the argument. You're just stating a different position. There's something really interesting going on here. Okay, let me, I need to try to keep the tempo at a certain pace so that I can get through as much material as possible, otherwise it's going to hurt me. For what it's worth, I'm an agnostic, okay? And let's say, you're a Christian, and you want to proselytize, you want to make a Christian of me, you want me to believe that God exists. And so you come to me and say something like this. Yo, Ken, the Bible is the Word of God, claim one, claim two, and the Bible says God exists, therefore God exists. Should that convince me?
It's circular logic.
There you go, it's circular. The reasoning is circular. It's assuming the very thing that it's trying to prove, namely that God exists. The Bible is the Word of God, already assumes the very thing I'm not convinced of. And the problem with this argument is it's exactly the same. I'm not an originalist. I'm radically opposed to originalism. This argument is circular because essentially this is the very claim that's at issue. The argument is presupposing, assuming the very thing that it's supposed to prove. Everybody see it? It's kind of pretty. Sometimes there's so much beauty to be had in arguments, even arguments that don't work, that as lawyers, one of the things that will be, I think, there's somewhat, I mean, I practiced law for 8 months, I hated it, so I'm a theory guy. But one of the things that I love about arguments is that sometimes the mistakes are really subtle in beautiful ways. Man, it's a beautiful undertaking. Reasoning is a beautiful, beautiful thing to do. All right, arguments against. Now, this argument persuades me. It may not persuade you. In fact, I gave this lecture, a similar lecture last week in Professor Tomaci's class, and he didn't find this persuasive at all. Okay, so we just, did I pronounce that right? Pronounce his name right? Okay, all right. Huh? So he wasn't persuaded at all. This persuades me. Personally, I don't care what people thought 229 years ago. Why is that relevant? Why should that bind us? Look, don't get me wrong, you know, I don't have nothing against white men or old white men. I happen to be both. I'm old and I'm white. But the Constitution was written entirely by a bunch of old white men and who lived at a time when racism, sexism ruled and the world was a very different place. People at that time couldn't even begun to have imagined the kinds of problems that we face today. They were in no position to lay out a rule that would actually bind people 229 years later. And it seems to me, okay, to be effective and legitimate, the law must reflect the present circumstances of any society with all its nuances. And here's this I omitted during the last presentation, and when I heard Professor Tomaci's objections, I realized I needed to fill in one gap here. And here's how I fill the gap. If you think that the legitimacy of a government, and remember, look, law is coercive. Law does something really, really wild. Law tells you what to do and then backs its commands up with the threat of violence. You know, go out and break a law and try resisting arrest, I guarantee you, well, I can't speak for Serbia, but I can speak for the US, I guarantee you you'll have a gun pointed at you real quick. And in the US, cops ain't afraid to shoot. That has to be justified. Nobody else gets to tell people what to do and back it up with the threat of a gun. So it seems to me that part of what justifies or has to justify any legal system is that people consent to being told what to do. And the reason this argument is important, or it convinces me, is this. Interpretations, judicial holdings are far more likely to be accepted and consented to if they reflect the existing circumstances of the time than if they reflect some understanding that's archaic and antique 229 years earlier. That's the arguments for and against. I mean, there are many more for and against, but that's all I have time to really cover. The second approach is the approach I favor. And let me be real honest about this. There are objections to this theory that I don't have an answer to. So I'm in an interesting position. I believe in the power of reason. I want to make sure that whatever views that I hold, I can defend. I can back up with an argument. I think that's really important. You know, especially when in connection with law, because law restricts people's freedom. And if we're going to support a law, we ought to have some kind of argument behind it. We should have some reason to think we're doing the right thing. Okay, so that means that, you know, the view that my comprehensive sense of the picture is somewhat defective because I have a view that I can't fully defend. And I'm not ashamed to admit that. I think it's important to know when you don't have an answer to an argument. Too many people hold views and never recognize that they don't have adequate reasons for holding it. And that bothers me, especially if you want to be restricting my freedom, because I'm the kind of guy who likes to do whatever he wants to do. And most of the time does whatever he wants to do, because that's the kind of guy I am. So this is called the moral reading. It's warm as hell in here. You know, pretty soon, man, this shirt's gonna come off. Yeah, sorry about that. The moral reading is also a fixed content approach. And it makes a really interesting assumption about the nature of morality. So before I explain the approach, let me give you two different theories of morality. According to one view, morality is a social artifact. It's conventional. It's manufactured by human beings. It's cultural relativism. What moral principles apply in one culture may not apply in another culture because morality is manufactured by culture. Whatever moral principles people in a given culture accept, those are the principles that govern the culture. So, for example, and I'm actually sneaking in an argument against this view, if there's a culture that thinks that it's morally permissible to set babies on fire for fun, then in that culture it's morally acceptable. And it doesn't make sense for another culture to criticize that culture because, hey, morality is manufactured by culture. It's their business, they made it, it's their morality. Why should our views take precedent over the views of another culture? The other view is called moral objectivism. And that actually happens to be the view that most people take whether they know it or not. Because I'd be willing to bet most people in the room do not believe that it could be possible for it to be right to set babies on fire for fun. And if that's the case, then you are what's called an objectivist, which means that on your view, if you hold it, morality isn't manufactured by culture. It doesn't depend on what people believe or accept. Morality is like mathematics, right? 2 + 2 = 4, regardless of what you think. You know, the shape of the earth is roughly spherical, regardless of what you think. Those are examples of objective truths, right? Objective truths, well, contrast them with a truth that is subjective. I hate certain cheeses. Blue cheese is disgusting to me. It tastes like vomit. I don't know how anybody eats that, right? So I would claim blue cheese is disgusting. That's not objective, that's subjective. It varies from person to person. Whether or not a subjective claim is true depends on the view depends on your view. And then there's the moral conventionalism, that's just cultural relativism. Morality isn't manufactured by a single individual or relative to a particular individual, it's manufactured by a group. Now, according to the moral reading theory of constitutional interpretation, the text of the Constitution should be interpreted in accordance with the requirements of objective morality. Not what people think is moral, not their views about morality, the objective requirements of morality. On this view, the Constitution clearly uses the language of morality. The U.S. Constitution is just it's all over the place. Rights, unreasonable, you can find moral language scattered throughout the Constitution. And according to this theory, those terms should be interpreted according to the objective moral meaning that they have. So, what judges must do in interpreting the Constitution is to identify the objective moral meaning of the terms and principles. So, let's take a look first at an example. Brown v. Board of Education. Brown v. Board of Education, as far as many people are concerned, and most scholars are concerned, is one of the greatest cases in U.S. constitutional history. Before Antonin Scalia was appointed to the court, Ronald Reagan tried to appointed another originalist, a guy by the name of Robert Bork. And Robert Bork wasn't confirmed, right? He got himself into big trouble with respect to certain cases, one of which we'll talk about later. But even Robert Bork found himself having to say Brown v. Board of Education was the right decision. Because Brown v. Board of Education overturned Plessy, the case we talked about earlier, that held that public school racial segregation was constitutional. Brown v. Board of Education held that separate is inherently unequal, whereas Plessy held that public school segregation was okay as long as the facilities were separate but equal. Now, Brown could not have been decided on the basis of an originalist theory. Why? Because we saw at the time Plessy was decided, most states allowed or required public school segregation by race. Nor could Brown v. Board of Education be decided on the strength of relying on people's moral views about public school segregation. Brown v. Board of Education caused as big a stir, if not bigger, than the marriage in the U.S. as the marriage equality case, Obergefell. So controversial was this case that the Supreme Court waited. Brown was decided in 1954. Public school segregation, unconstitutional, has to be stopped. They waited 18 years to enforce that decision because they were afraid it would start a civil war again. And the year they started, just to give you a sense of how big a difference this made, the year that they started enforcing Brown was the first year I went to high school. The high school I went to, the year before I went, was 97% white. The year after, it was 70% black. The court had ordered busing as a means of desegregating the public school system. The only way that you can make sense of Brown is, or make sense of how the court decided Brown, is you have to assume that they were using a moral reading theory of constitutional interpretation. You see what a big deal it makes which theory of constitutional interpretation you choose? And again, theory is important to practice. I can't emphasize that enough. All right, here's the main argument for the moral reading, and I don't know if I'll do justice to this because it's complicated, and I've rewritten this several times, and I don't feel, I mean, I understand what I'm saying, but I don't feel I've expressed myself clearly enough. It's a beautiful argument. What Dworkin does is he takes a slightly different theory of constitutional interpretation than originalism and make it support the moral reading theory. Related to originalism is a theory, a framer's intent theory of constitutional interpretation. According to the framer's intent theory, the meaning of a constitution should be interpreted in accordance with the intent of the framers. So Dworkin does something, man, he takes a little hat and pulls one big-ass rabbit out of that hat. This is absolutely breathtakingly beautiful, and I hope I can express this clearly enough to convey the beauty. It's subject to objections, and this is where I get into trouble because it's subject to an objection I can't answer, and I'll be honest about that. Now, obviously, the framers had certain beliefs about what free speech covered, or what the right to bear arms covered, or what the right to be free of unreasonable searches and seizures covered. Clearly they have beliefs about this. Okay, now if we assume that the framers were decent people, there's an issue. Morally decent people, there's an issue that arises. Suppose the framers, okay, some of their views are going to be mistaken. And the question is this: do you think that the framers intended the Constitution to incorporate their morally mistaken views, specific views about particular cases, or do you think that the framers intended that that the Constitution that their moral mistakes be disregarded, that the Constitution be interpreted in a morally correct way? Dworkin argues, and this seems very reasonable to me if we assume the framers are decent people, is that what they intended was the morally correct reading. And they would say, look, if I turn out to be wrong about this, then don't interpret the Constitution in accordance with my mistaken belief. I want the Constitution to provide protections that cohere, that are consistent with, and satisfy objective morality. I don't want the Constitution to, I don't want my moral mistakes to govern people. I want to make sure that the Constitution provides protections that truly satisfy morality. That's the argument in favor of the moral reading. So the idea here is if you start from framers' intent, you're not going to get that what the framers want is for courts 200 years later to interpret the Constitution in accordance with morally mistaken views if they know those views are morally mistaken. They're going to want the Constitution interpreted in accordance with the correct results. This is, on my view, just a breathtakingly beautiful argument. And here's where I get into trouble. And I can't answer this. If we assume that morality is objective, nobody has infallible access to the moral truths, right? It's not like any of us can claim on the assumption that morality consists of mind-independent truths to be infallible, utterly infallible with respect to the requirements of morality. In fact, the best we can do, all of us, we just have opinions about what morality requires, and we try to justify those opinions by arguments, because a view that is backed by a good argument is far more likely to be true than a view that is backed by no argument or bad arguments. That's the whole point of arguments. Arguments make it more likely that the conclusion is true. So the better the argument, the more likely that you're going to get something right. The problem here is that when it comes to morality, the best we can do, any of us can do, is give an opinion. Now, why is that a problem when it comes to constitutional interpretation? Because it now begins to look truly anti-democratic. Because even if morality is objective, if it's true that none of us have infallible or especially reliable access to the truth, and we all have simply opinions that may or may not be correct. What justices are doing when they interpret the Constitution according to the moral reading is impose their own moral views on the rest of us, and that seems undemocratic. Why should the justices' own flawed opinions about morality, why should that be the law of the land in a country, in a nation, in a legal system that is democratic in character? Did I do okay with this? Did I make sense? Okay, good. It's really good to see you. I sent you a message earlier.
Again, what about this famous natural law argument that moral truths are self-evident? Then we don't need no one to have a special access because it's self-evident. Because when you say it's morally wrong to set babies on fire, that seems to be quite self-evident. That basically you are appealing to the self-evidence of this sentence. No one of us requires any special kind of a knowledge or the procedural means to access to this statement to determine whether it's morally true or not. Basically, you are the evidence of this statement.
Well, this particular statement seems self-evident, if any are, but I'd be willing to bet there are a whole lot of people in here who disagree with my view that morality requires that the government legalize same-sex marriage. So we have disagreements about morality all the time. In the U.S., I'm curious, is abortion controversial here? Is there a strong pro-life movement? Okay, well, there you have it. The pro-life position is that abortion is murder. Why? Because the fetus is a person.
But it's far less controversial than.
Yeah, but my point is just that there's disagreement. Just to respond to your objection that according to natural law theory, moral truths are self-evident. Some are, but not many are. We disagree as far as I can tell. Well, actually, that's not true. We don't disagree on more than we disagree. We don't disagree on more than we agree with. Everybody thinks, you know, stealing is wrong, killing innocent people is wrong, rape is wrong, and a bunch of other stuff is wrong. But we disagree on a whole lot, and that can only be the case if morality is not self-evident. And that much, I think, is, as far as I'm concerned, I mean, that much is clear. Now we come to a living tree approach. This derives from this was the view first articulated by Justice William Brennan, who it was probably one of the most liberal justices in Supreme Court history, and one of my heroes. I adore Justice Brennan. He took the position that the Constitution should be interpreted in accordance with evolving standards of decency. Evolving standards of decency. Now, the claim here is not that the Constitution should be interpreted in accordance with the objectively correct morality. The view is that it should be interpreted in accordance with people's evolving views, what they believe about morality. That's a very, very different claim. And so, look, people's beliefs about morality change over time. You know, there was a time in the United States where everybody thought, as a moral matter, black people were subhuman and less deserving of moral respect. There are still, unfortunately, some people in the United States who believe that, but the vast majority of people don't believe that, although very subtle unconscious forms of racism persist. And that's something we're really, really struggling with at the present time. So since people's beliefs about morality change over time, and their beliefs define the content of the Constitution, then the content of the Constitution changes over time, and that's what makes it a living tree approach. It's called evolutionism. All right. Let's go back to the marriage equality case. You know, I have very strong views about gay rights, you know, and to be perfectly honest with you, in part because I've been victimized by homophobia. I'm straight, but, you know, people frequently think I'm gay on the basis of, you know, the way I dress. I mean, a few years ago, I used to wear makeup when I was young. I used to wear eyeliner. You know, I like wearing eyeliner, but I'm a little too old to carry it. I've actually been assaulted here. 2 people ran up behind me because they thought I was gay and tried to knock me down. They didn't, and they wound up running from me to the police, which was very lucky for all of us, because I was catching up on one of them, and I did time on the streets, you know. I used to be a drug addict and a criminal, and I know how to handle myself. I'm not the man you want to mess with, unless you're really good at messing with people. So, I know what that feels like. I know what it feels like to be victimized by homophobia. I got a personal stake in it. Look, I like women. You know, I love me some women, you know. But I don't care whether you think I'm gay. I don't give a damn what you think. I really don't. I don't care if you think I'm gay. It don't matter to me at all. I care about how you act towards me. Say something to me. We got a problem. Put your hands on me. We got a bigger problem. Or rather, you got a bigger problem unless you're more skilled than I am. Well, I'm always up to see. Okay, so if you look at Brennan's evolutionist approach, it actually supports the marriage equality decision. Now, I'll be honest about this. Like I say, I'm a very strong advocate of gay rights, but I got to admit, I was kind of surprised when the Supreme Court did this. I couldn't believe that the Supreme Court legalized marriage equality. Because, and at some level, there was almost no point to doing so, because it was inevitable that all the states would eventually legalize gay marriage anyway. And by gay marriage, I mean, you know, not just civil unions, calling it marriage. I understand there are a whole lot of folks who, you know, are in favor of civil unions for gay people who want to withhold the marriage term. Me, I'm all the way down on the marriage equality issue. Call it marriage. Or let's just take, when it comes to the state, let's just take the word marriage out of it. Marriage is actually sacramental. It's a church institution. Why the state issues marriage, quote, marriage licenses is beyond me. Just call them all civil unions, but treat them the same as far as I'm concerned. But still, I mean, for a court to do this was astounding. Was absolutely astounding to me. I couldn't believe it. I was happy about it, but, you know, again, if you look at the political campaign in the United States, it's a very angry campaign, and I think our country, my country, the U.S. is in big time trouble. We're going to see a whole lot of violence, and part of it is because of the reaction to the Obergefell decision. But look, if you take a poll, the majority of people in the United States support gay marriage, the majority. Young people are almost overwhelmingly in favor of it. Overwhelmingly in favor of it. Reason for that is gay people started coming out. You can't do that here. You can't come out here yet. Right? In the 70s, people started coming out, and all of a sudden, you know, people found that they have friends who were gay, and they were like, wow, man, he's not an abomination, she's not an abomination, they're great people, I love them. And so, psychologically, it changed the way they thought about homosexuality. But according to the evolutionist approach, since the majority of people in the United States have come to believe that it's okay, if you accept Brennan's theory, then that the Constitution should be interpreted in accordance with evolving standards of decency, then you're going to get, at least in the U.S., marriage equality. Might not get it here, right? I mean, people have different views in different cultures. You know, in the U.S., gay marriage has become pretty much accepted. Younger people, overwhelmingly in favor of it. Older people tend to be against it. Brown v. Board of Education. I want to say very quickly, I want to follow up on what I said earlier about Brown. As I said, Brown v. Board, the only way to make sense of Brown v. Board of Education is to think that the justices were trying to decide the issue in accordance with the objective requirements of morality. And the reason for that, right, clearly it couldn't be justified by an originalist interpretation, because at the time the Equal Protection Clause was ratified, most states allowed or required public school segregation. And it couldn't be justified by William Brennan's evolutionist approach, because at the time Brown v. Board of Education, people went apeshit against it. They were pissed. They couldn't believe. The reaction was worse than the reaction to the Obergefell decision. As I said, it was so bad that the Supreme Court waited 18 years to enforce it. So, if you accept Brennan's theory, Brown v. Board of Education was wrongly decided at the time it was decided, but it would, if it came before the court now, be correctly decided. See, that's why it's a living tree approach. By the way, how am I doing for time? Okay, I'm actually going to do pretty well. Okay, here are the arguments in favor. No one knows what true morality requires. You know, we saw that that's an objection to the moral reading theory, but it's an argument in favor of Brennan's evolutionist approach. If no one knows what morality actually requires, and morality is relevant with respect respect to deciding constitutional cases, then the only thing left is to look at what people think at the particular time the case arises. The other, and this is a very powerful consideration as well, the rationale for doing so, again, is if you, one of the most prominent justifications for legal systems coercively restricting freedom, again, right, law is backed up with the threat of guns, and you need a justification in order to do that. Most people think that whatever justifies the state in coercively telling you what to do, it has to be grounded at least in part on the consent of the people. So here's the beauty of this. If you are interpreting the Constitution in accordance with the people's evolving views about morality, the results are more likely to be acceptable to the public and hence promote consent to being governed. I think that's the most powerful argument for evolutionism. But there are arguments against, and really good ones. And the major one is this. Excuse me, I'm sorry, my mouth is getting really dry. It is so warm in here. Excuse me for that. But it's much hotter up here, I think, than it is over there. The concern is, look, if you start governing, if judges start making decisions in accordance with the views of the people, then you're kind of defeating the purpose of having constitutional rights in the first place. Right? Because what are constitutional rights supposed to do? Look, democracy is a beautiful thing, but pure democracy without constraint is frightening, because there's always the possibility that a majority tyrannize a minority, which, well, we have a wonderful history of that, starting with black people, and now you got presidential candidates proposing, not only banning Muslims from immigrating or coming into the country, something like, oh, I wish I remember the number, it was absolutely appalling. 30-40% of Ted Cruz supporters favor making Islam illegal. Making Islam illegal. Making it illegal to believe Islam. See, that's exactly the kind of tyranny that having constitutional rights protects against. You know, a democratically elected legislature can do a lot of things, but there's certain things it can't do. And the very point of having these limits on democratic legislative authority is to protect against the tyranny of the majority. The problem is that, look, if you're just deciding constitutional cases according to what people believe, then, well, hell, you pretty much defeated. There's no real constitutional protection at all, because the majority will always wind up winning, and that defeats the point of constitutional rights. And I think I can stop here. I have a little bit more, but there's no way I can get through it. Just one really quick comment. Most Supreme Court justices are purists in the sense that they hold just one theory. Justice Scalia held one theory. He was an originalist. Brennan was an evolutionist. Okay, but then there are a number of judges are what are called pragmatists. They tend to hold a variety of different theories and mix them together, or use one or the other depending on what the circumstances of the case are and how they make these decisions. Well, my suspicion is it's results driven. I can't criticize that because I'd probably be doing the same thing if I was a justice. But as a general matter, most justices hold one theory. Some hold a number of theories and decide cases in accordance with a number of theories. And I guess I'll stop here and we can do some Q&A. It's warm. Questions, comments, concerns, observations, insights, gripes, complaints, well wishes? Thank you for rescuing me from this very awkward silence.
Okay, I love talking. I would just disagree about one thing. I think that the aim of any law shouldn't be morality, because morality is something subjective. So maybe for me one thing is moral, for you that thing isn't. I think that justice, or I don't like the term, but social justice should be the aim of every law. Not morality, because it's not the same for everyone, but social justice is a term where we can say that it contains the same rights for everyone. So I think that's better to say that the aim of any law shouldn't be morality. It should be or public morality, maybe public morality, or justice.
Well, I guess I would say this. It seems to me that justice is actually a particular category of morality. Whether or not something is just or unjust. Look, if you do something to me that's unjust, you're also doing something, it seems to me, that's morally wrong, right? I mean, if I do something unjust to you, then you have a right to get angry and criticize me, but the criticism will be moral grounds. Fairness is also another moral notion. Justice just describes several types, subclasses of morality. There's economic justice, for example. How, from a moral standpoint, the resources of a society should be distributed among the people. There's procedural justice, right, which involves, when it comes to court cases, which involves moral claims about how courts should proceed. I'll give you an example. Forgive me for this, because I'm actually going to make a criticism of the Serbian criminal justice system, because I actually have a friend who's in some rather serious trouble with the criminal justice system, and her trial's been going on for 2 years. 2 years. Court meets once a month. Once a month. Not only is this inefficient, because every time the court meets, right, they have to review, go over again all of these materials, because it's been a month since they've last thought about it, but it delays, it puts people's lives on hold for a very long time. And it's inefficient in another respect. If someone is placed in jail during the duration of a trial and they're found innocent, they got to be compensated. Right? And the reason for that is because you put them in jail for a very long time. A trial in here can go on, a criminal trial in here can go on for 3 years, 4 years. In the United States, we have a right to a speedy trial. Most criminal trials can be decided in 7 days, and they are. Some cases require a little bit more, and then there's the appellate process and all of that. That can go on forever. But at the trial court level, we have a right, in the case of criminal cases, to a speedy trial. And it seems to me as a moral matter, and forgive me, I don't mean to be, coming in here from America criticizing your country. I've said much more by way of criticism of my own country than this one criticism of the Serbian criminal justice system. Right, that's a matter of procedural justice, but it also seems to be a matter of morality. So I think that notions like justice and fairness are just subcategories of morality. I might be right, I might be wrong, but thank you for the question. It was extremely insightful, as was your earlier question.
Okay, so as far as you mentioned about objective morality, and Jose you mentioned in the martial law about morality being self-evident, apart from the self-evident construct, maybe we should think towards rationality being the source of the agreeing points as far as arguments are concerned. That's one point. And the second point, why do you think that people who court justices should take a purist approach to deciding certain matters instead of being pragmatists, even though I think you're using a different definition of pragmatism in this specific case?
To tell you the truth, while I tend to think the moral reading is the right reading, I also know that, if I were a judge, I would probably be driven more by results, and so I would combine, okay, maybe pragmatist is the wrong way to put it, fair enough, that's actually correct. And actually is the last surprise. Forgive me, that's not what I mean. I'm a pluralist. I would be a pluralist in practice and theory. I subscribe to a single theory, that's an intellectual problem for me because my beliefs don't line up, and that means I have some work to do. As for your first point about rationality, I take the point to be something like this, that the kinds of considerations that should justify a theory of constitutional interpretation should be principles of rationality. Well, look, it all depends on what you mean by principles of rationality. If by principles of rationality you simply mean principles of correct reasoning, then it's hard to see that that's going to get you anything substantive with respect to justifying any particular theory of constitutional interpretation. Look, here's an example of a problem of rationality. My views don't line up, right? So there's an inconsistency in my views, which means I'm violating principles of rationality which govern how one should think about things. So if you mean practical rationality in a narrow sense, and sometimes people mean it in that narrow sense, then you're not going to get you're just not going to get any mileage out of that. You know, there's just not enough, the notion isn't robust enough to do the work you want it to do. Now, if you broaden it, and on my view, principles of rationality also include principles of morality. I think that there's something, and this is highly contentious, okay, and I'm aware of this. A philosopher, the first philosopher to hold this view was Immanuel Kant. He wanted to show that moral principles could be derived from principles of rationality. Just about everybody thinks he's failed, although the theory and the arguments are breathtakingly beautiful. But my view isn't that you can derive morality from the kinds of principles of rationality that Kant tried to do. Kant saw principles of rationality. He defined it in the narrow sense I first discussed, and he thought he could pull moral principles out of that hat. I just think in general, principles of rationality include principles that govern how you should behave in order to maximize your self-interest, right? If I want to go to Serbia, and all I do is buy a plane ticket to San Francisco, then there's something irrational there. I haven't thought the problem through correctly. I also think that principles of rationality include moral principles, and that's commonly principles of practical rationality. Practical rationality is construed in such a way as to include moral principles. That's the more robust conception, but if that's what you mean, then, well, essentially, the argument's going to be moral in character and subject, as all arguments are, to principles of how to go about thinking about certain problems. Other comments or questions? Yes, please, sir.
I want to say something about the idea of origin. One said Paul, and that the judge said that it's deceased and the process got raised without it.
No, that was probably not a nice thing to say.
That's not the point. When one looks at you, with all respect, you're written liberal from head to toe. And I have no problem about that. I want to say that the whole U.S. constitutional history is based upon originalism, one could say, because you have the oldest constitution in the world. It's over 200 years old, and you keep arguing about evolutionism and originalism. I mean, in your country, why don't you just change the text of the Constitution, make a new one, and there will be no need for fighting between originalism and evolutionism. It's in its idea, in its core, your Constitution has I'd say a right base for a lot of arguing. Why not just change it in some upcoming years? And what's the reason for well for over 200 years.
Well, actually, I mean, it's not the case that the judges have historically been deciding cases according to originalism since the very beginning. Originalism is a comparatively new theory of interpretation. Justices for example, in 1954, as I said, there are cases decided that are inconsistent with originalism. You can go further back, you can go all the way back to Marbury versus Madison. The very first case in which the Supreme Court declared that they had authority over the Constitution. There have been a plurality of different theories of interpretation for a long time. Originalism is a comparatively recent development. As for my being a liberal, yeah, you're right, and let me apologize for the remark about Scalia. Yeah, but this idea that, again, this idea that I think you're clearly an originalist. So what an originalist would say is, look, if you want to change the meaning of the Constitution, there's a procedure that's defined in the amendments. Just follow the procedure, amend the Constitution. Seems to me, though, that you're still assuming what has to be proved, namely that originalism is the right theory of what the Constitution means, so that it's the only way that the meaning can evolve or constitutional provisions can change is by amending the Constitution. I would disagree with that assumption. I mean, that's exactly, I think, what's at dispute between us. But your point is well taken, and really, the comment about Scalia was in very, very poor taste. And I apologize for that.
That wasn't the point.
No. It was enough. You did mention it, so it was kind of the point. And yeah, you're right, I'm a liberal. And I'm upfront about that. And you should take that into account in evaluating my views and my arguments. Okay, I think...
Yeah, well, I'm sure you all have, after the ice melts, you probably have a million questions. I have a few questions about Scalia and originalism, but we'll have to stop here. Our next lecturer has a time frame that she has to respect. We have to finish until 10 minutes to 8. So let us give another hand to Kenneth to take Cam for the wonderful lecture. Thank you. 7-minute pause. You can drinks and stuff here, and after that we will continue with the lecture of Dragan Vojnović about. So thank you.
And thank you very much for being here and for your participation. I really enjoyed it. I learned from it. I learned something about bad manners. I shouldn't have said that. Thank you for that. Anyway, I enjoyed it.